Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today we will share some details of our brief encounter with Mr Malkinson in a campaign recently launched as part of their racial justice initiative by Appeal, a UK charity and law practice dedicated to fighting miscarriages of justice and demanding reform, and which was instrumental in securing the quashing of Mr Malkinson's wrongful conviction. On the 8th of May 2024, we attended an event hosted by Appeal to mark the launch of a new campaign linked to jury verdicts under the compelling, poignant and impactful title, Doubt Dismissed. The report on which the campaign is based, which you can see scrolling now on the screen, is rather packed with a lot of information which might appear daunting. However, Appeal have produced a very compelling and easy to follow video which I recommend you to watch. I will provide the link to the report and the video in the description below. In short, the video remarks that juries are safeguards against state power and state abuse. However, juries are under attack. Indeed, the first attack on juries was perpetrated in 1967 when the unanimity requirement was scrapped and the majority rule was introduced. The video states that this was done with no public consent. However, for fairness and balance, I would mention here that this is not strictly correct. Roy Jenkins, the then Home Secretary, told the House of Parliament on the 12th of December 1966 during a common sitting that the Gallup poll conducted a survey of public opinion on this matter and found that 72% of those questioned were in favour of the majority verdict by 10-2, that 11% were against, and that 17% did not know. Though we don't have further details of this poll, there appears to have been some substantial backup from the public at the time, 72% in fact. However, as we explained in our video, majority verdicts passed in haste, time to reconsider, the narrative provided at the time was that there was an emerging trend of jury nobbling. That is, the one or two jurors were effectively being bribed by criminals to frustrate the process of justice, and which was causing major criminals who do not commit crime themselves but organize others to do it for them, to escape justice. As we know, however, very little evidence of jury nobbling was effectively provided. So we could really say that, in fact, the Gallup poll did not accurately represent the true public's perspective. Their understanding of the issue was incomplete, leaving them misinformed, and their opinions, therefore, based on an unsubstantiated narrative. That said, the campaign is based on valid research and one that we fully support. In a nutshell, the research found that 15% of Crown Court convictions are reached by majority verdicts where up to 2 jurors disagree, their doubts therefore being dismissed. Hence the title of the campaign. They also say there is possibly a pattern here that makes this point stronger. They provide a list of over 50 convictions which have now been quashed where decisions were reached by majority. In addition, we have looked into the research of Rupert Macey-Dare, also recently published and also relying amongst others on Mr Malkinson's case to confirm his point, which gives insight into how a majority, as opposed to unanimous guilty verdict, can produce a very high biased overestimate of the jury. This is because, he says, the mathematics of voting is different from and inconsistent with the mathematics of probability and optimal statistical estimation of guilt. We have covered this research in great details in our video Majority Verdicts Beyond Reasonable Doubt. If you have missed it, you can find it linked in the description below. So what are the recommendations made by appeal? Obviously, first and foremost, they recommend reinstating unanimity of jury verdicts. But this is not the only recommendation. But before examining the remaining recommendations, if you are finding this video useful, do like and subscribe to our channel to help us in our mission to humanize wrongful convictions. Going back to the doubt dismissed campaign, a second recommendation appeal makes is to amend Section 8 of the Contempt of Court Act 1981, which states that it is a contempt of court to obtain, disclose or solicit any particulars of statements made, opinions expressed, arguments advanced, or votes cast by members of a jury in the course of their deliberations in any legal proceedings. They say, and we agree, that this section should be amended to allow researchers to conduct studies of real juries in real cases. This is in fact also a recommendation that featured in a report titled The Contempt of Court, Juror Misconduct and Internet Publications, produced by the Law Commission in 2013. They also recommend that more data on majority verdicts, jury composition and voting splits needs to be made available to determine whether majority verdicts are more common in convictions that have been overturned or upon which doubt has been cast. They therefore call for Crown Courts to capture and to record detailed data on majority verdicts and juries, and for appeal bodies, namely the Court of Appeal and the Criminal Cases Review Commission, to record data on verdict type. This approach, which is evidence-based, brings me to the very interesting presentation given at the same conference by Dr. David Sellu, a doctor who was found guilty by a majority of 10-2 of gross negligent manslaughter of one of his patients and was sentenced to 2.5 years in prison in November 2013. His conviction was subsequently quashed on grounds of jury misdirection by the trial judge in November 2016. In his very interesting presentation, he showed the complex and long process surrounding medical research and the various stages and clinical trials needed for a medical research to become established. In contrast, convictions that may result in a person spending the rest of their life in prison, akin to the nightmare of being buried alive, require only circumstantial evidence and are upheld even when 1 or 2 jurors have expressed reasonable doubt. Astonishing. Mr. Malkinson's intervention to the event was left to last and consisted of specific questions asked by his lawyer, Emily Bolton. Amongst others, she asked Mr. Malkinson how was the split verdict, which we know was a 10-2, significant in his own case? To which he replied, if it hadn't been for the reversal of unanimity, I wouldn't have been convicted because it wouldn't have been permissible. I would have had a normal life and not had 20 years of fighting to get to the truth, whilst certain state actors deliberately withheld evidence, indeed manufactured evidence and false witnesses. Ms. Bolton's final question was whether Mr. Malkinson had any comments to make on whether the fact that the police failed to disclose evidence in his case could be considered jury nobbling on the other side. To which he responded, well, yes, absolutely. It is jury nobbling, isn't it? It is manipulating. It is not furnishing the jury with all the details. They have misinformed and deceived them with false misinformation, so you can't blame them. The question and answer session was also quite revealing, with one particularly alarming point raised by a lawyer. The lawyer noted the defense counsels often avoid bringing well-founded jury impropriety claims to the Court of Appeal due to the court's anticipated dismissive and contemptuous response. She shared that she had attempted this in one of her cases, which was ultimately successful, but on a different and more widely accepted ground. This is deeply troubling and disturbing, and illustrates how easily miscarriages of justice can be perpetuated if defense counsels are intimidated by the Court of Appeal's preconceived stance on certain issues, dismissing them outright from the start. This also explains why only some wrongful conviction cases succeed on appeal. Success typically occurs in cases where confident, bold and audacious defense counsels handle the appeal, which demonstrates how crucial the choice of counsel is in appeals. Finally, as promised, here is our experience of meeting Mr. Malkinson. If you recall, in our video Psychological Impact of Wrongful Accusations, Professor Greenberg proposed that one way to support wrongfully convicted individuals seeking to overturn their convictions is to connect them with others who have faced similar situations and successfully cleared their names. This approach, he said, would also help those who have cleared their names to heal from the moral injury they have endured. So I attempted to reach out to Mr. Malkinson after the event with the aim to determining his level of interest in this process. So I explained the situation. I gave him our card with our details. However, this was promptly confiscated by Miss Bolton. I understand that this was done with a noble intent, so we did not take offense at the situation. We are respectful and mindful of the difficult circumstances. As per my impression of Mr. Mackinson, was of that of a kind and courteous individual who, despite the difficult journey he had to endure, remains remarkably composed and dignified, a characteristic typical of those who have been wrongfully convicted. This concludes today's session. Join me next week for our monthly news session. In the meantime, join our networking hub at spokeninjustice.net and like this video if you have enjoyed it, and subscribe to our channel if you have not done so already, to help us in our collective effort to humanize wrongful convictions. Look forward to usher you as we sit and rise in this unique trial.